A lot of you guys are asking about the Dignity Act of 2025, so I'm going to do a breakdown, an extensive breakdown, as an attorney practicing in immigration. I'm just going to point out to you guys what I think really sticks out. So first, there's going to be criminal enforcement provisions, such as DNA testing and collection consistent with federal law. There's going to be mandatory E-Verify, which would preempt the state's rights. There'd be use of employment eligibility verification photo tools. There's going to be asylum reform, trying to get expedited asylum determinations, and recording of expedited removal and credible fear interviews. In my experience, credible fear interviews are already recorded and transcribed, so I'm not really sure where that's going with that one, but expedited removal, they don't really have that, so that's very new. There's going to be a two-strike policy in asylum reform, and I'll get into all the details later. There's going to be a Dignity and American Dream Act, which looks similar to the DACA Act, and that's going to be a permanent resident status on a conditional basis for certain long-term residents who entered the United States as children. And there's going to be terms of permanent resident status offered on a conditional basis. There's also going to be the American Promise Act, which is adjustment of status for certain nationals or certain countries designated for temporary protected status. And just as a beginning thing for you guys, this hasn't been passed yet. This is just to go over it just in the case that it does pass, because it is a bipartisan bill, and it's really important to go over this and understand really what's going on behind it. The act presupposes that there's going to be limitation on removal and other conditions on certain eligible individuals, exemption from numerical limitations, and availability of administrative and judicial review. Also, it looks like they're looking to supply grants to access high-demand careers. There's going to be an American Family Unity Program, which the chapter states discretionary authority with respect to family members of United States citizens. And there's also going to be reform on motions to reopen and motions to reconsider. There is a Temporary Family Visitation Act, which states for family purpose, non-immigrant visas of relatives and United States citizens are going to be affected. And there's also a different section regarding spouses and children of an alien lawfully admitted for permanent residence. And that chapter states most basically that spouses or children of an alien are lawfully admitted for permanent residence. There's a title called Fairness for Legal Immigrants, and under that title, there is a section called Protecting the Status of Children Affected by Delays in Visa Availability. And there's also a title called Improving Employment-Based Visas. There's a section on student visas and visa processing, and it states that there's going to be some modernization of visas for students. There's also a lot about border security and strengthening the border and air and marine operations, the Southern Border Threat Analysis, a border plan, training of officers of ICE, Border Patrol, establishing higher minimum rates of pay. Something that really stuck out to me was body-worn camera pilot program authorization. Authorizes the body-worn pilot program that would be established for an additional 5 years that deploys body cameras for U.S. Immigrations and Customs Enforcement agents during certain operations. This is really interesting because I'm sure that this body-worn camera will be used to show a lack of probable cause or probable cause determinations, because as it stands now in immigration court, the arresting ICE officer does not write an affidavit that at least is supplied to the Immigration Counsel. And so there's a lack of accountability regarding if that immigrant was detained in a proper way and if there was probable cause to detain that immigrant. This distinction is actually really clear because I am practicing criminal law, and in the criminal law court, in state court, there is a probable cause determination that's made when a person is either seized of their person or their belongings are seized and there's a seizure. And there's an analysis to go over if there was probable cause, and so I do think that this could be about obtaining probable cause and either a lack of probable cause or something about how immigrants are being detained. I understand that's a huge issue and a problem right now that people are concerned about. Something that really stood out to me was there's going to be criminal enforcement provisions in the bill, and they are regarding illegal entry. Oftentimes, an individual will come into the United States and they might get expedited removed, but they may come back into the United States. And at that point, generally in my practice, I've seen that if there are 2 illegal entries, depending on when those illegal entries occurred, somebody could obtain a 10-year ban or just a ban on being able to come into the United States. And they could be put into ICE custody during the pendency of their court if they are eligible to have court. So this is very interesting that there is a section called Section 1304 Illegal Reentry, and it states, any alien who has been previously denied admission, removed, deported, and subsequently attempts to reenter shall be fined or imprisoned for up to 10 years. That's a lot more strict than what I believe currently it is, because generally if people come into the United States and they're here a second time within a 10-year period of time, they are banned, but they can get deported during the pendency of their court. So this looks like they could be imprisoned for up to 10 years, and that looks like a lot more serious than actually what's going on currently. There's a whole section under that in Section 1304 that says reentry of criminal offenders, and I'm just going to read it to you guys. If an alien, quote, if an alien previously removed or deported who has 3 or more misdemeanors or felony convictions tries to reenter, they shall be imprisoned for up to 15 years. It's actually a huge change that the bill is trying to go forward with. It also states if an alien previously removed or deported who has committed a felony and has a term of imprisonment of 30 months or more, they shall be fined or imprisoned for up to 20 years. So that's huge, because that's just a lot of time, and it's likely that the burden is very low of proof for that, and that's just huge to have such long prison sentences for a bill that is trying to add enhancements for people who have already entered illegally. So this is quite shocking in my opinion. Furthermore, the bill states if an alien previously removed or deported who has committed a felony that has a term of imprisonment of 60 months or more, they shall be fined or imprisoned for up to 25 years. I mean, these are life in prison sentences. So 60 months or more, a felony term of imprisonment means that somebody has a felony and they were in jail for 5 years or more. And if they're removed and come back, they could be imprisoned for 25 years. I mean, this is a huge issue to the American taxpayer if this bill were to move forward. Also, it states if an illegal alien previously removed has been convicted of murder, rape, kidnapping, or human trafficking, they shall be fined or imprisoned for up to 30 years. So these are just huge numbers, really big numbers. And where are these people going to be detained? Because it doesn't state. The bill also presupposes that there would be a mandatory minimum penalty for serious crimes such as child sex trafficking, which would be up to 25 years in prison. And it also states that there will be visa ineligibility for spouses and children of drug traffickers. Also, something interesting is that the bill states there will be employment eligibility photos where employers will use a photo tool to match a picture with the document provided by the employee. In regards to asylum reform, it states that reforming the system to adjudicate asylum claims within 60 days. In my opinion, that's very quick, especially that attorneys have to gather documents from their clients and prepare a whole trial and defense. So that doesn't sound really feasible in my perspective. The bill also states that for asylum reform, they want to end catch and release and establish humanitarian campuses near the United States southern border to expedite processing and quickly hear cases. So that's going to be really difficult if most of the time these individuals are going to be moving or in jail and have limited access to counsel, attorney, phones, their family. Follow for part 2 Let me know if you guys like this.